National Judicial Institute don break silence. Conflicting judgments no be sign of confusion. Dis na CenokMedia, the channel wey dey report the news and dey make am simple for everybody to understand. We dey thank una wey dey view us. Abeg subscribe if you never do so. Put on your notification bell. E go tell you as we drop update. Like, comment and share the video. My people, I greet una. Make una reason dis story wey we bring come so well. For our country today, plenty talk don dey fly left, right and center, especially about how courts dey drop different orders for the same political case. But today for Abuja, the National Judicial Institute don come and talk as e be. Make we break am down one step at a time. The administrator of the NJI, Justice Babatunde Adejumo, waka enter microphone for the pre-conference briefing of the 2025 All Nigerian Judges Conference, and im message clear: conflicting judgments no mean say judiciary don fail. According to am, dis kind differences dey happen naturally when judges dey interpret cases based on the facts, the evidence and the peculiarities wey each lawyer bring come court. Adejumo use the PDP National Convention matter as example, wey two courts for Abuja and Ibadan drop two different orders. But im tok say dis no be abnormal at all. To him, na part of the justice system wey dey help law evolve. E remind Nigerians say even for America, wey get one of the oldest legal systems, state courts still dey disagree on similar issues, and nobody dey use am take say system don collapse. Adejumo hammer one important point: if courts of equal power disagree, appellate courts dey to settle the confusion. From High Court to Court of Appeal to Supreme Court. Once Supreme Court talk finish, everybody gats follow. No lower court get right to form another direction. Even call am judicial rascality if any lower court try go against Supreme Court decision, unless na small clarification dem dey try do. But the NJI boss no stop there. E say we still need some reforms to reduce conflicting rulings. Im propose say before anybody file any matter, dem must swear affidavit say the case no dey anywhere else. If person lie, na perjury straight. Justice Adejumo still look back at a long journey for bench. E remember say when he entered the National Industrial Court, NICN, as president for 2003, the court get only 2 divisions and 123 staff. But through steady push, dem get the NIC Act 2006 and later constitutional amendment wey make the court a superior court of record, now the 4th highest court for Nigeria. The amendment even give the NIC president permanent seat inside NJC and FJSC, the highest judicial administrative bodies for the country. Adejumo still use the opportunity to correct one common misconception. Judges no dey do voyage of discovery. Dem no dey manufacture evidence give anybody. If prosecutor no prove am, court no dey force anything. For criminal cases, guilt must be beyond reasonable doubt. E repeat that old principle: better make 100 guilty people waka free than make one innocent person suffer wrong conviction. As Nigeria prepare for the 2025 All Nigerian Judges Conference, Adejumo tok say the goal na to improve judicial understanding, raise professional standards, and rebuild public trust for the justice system. This conference go be another chance for judges to check themselves, talk about public expectations, and refine the system wey everybody dey look up to. As we dey look this matter deeper, e get 5 fresh angles wey go help Nigerians understand the bigger picture. First, the PDP case itself gets serious implications. When courts dey drop different orders from different states, e fit slow party preparations, scatter internal planning, and even push party officials into last-minute confusion. Na this kind forum shopping, where people dey look for any court wey go favor them, the NJI dey try end with the new reforms. Second angle be the role of media pressure. Social media dey quick turn ordinary legal disagreements into big national drama. Sometimes, small procedural difference wey lawyers understand well go suddenly look like judicial collapse because online narratives don exaggerate am. Adejumo dey try calm dis public ten sion by explaining how the system actually work. Third, we gats reason the effect on Nigeria heading into 2027 elections. If reforms enter now, especially the affidavit requirement and tighter filing rules, e fit reduce the usual pre-election injunction battles wey dey choke courtrooms every election cycle. Dis one go make the political space more stable before primaries and national convention season begin. The fourth angle na the cost of litigation abuse. Many politicians dey file the same case for 2 or 3 states at once, hoping one court go favor them. Dis nonsense dey waste judicial time, drain resources, and make innocent citizens wait longer for their own cases. Adejumo reform wey link false affidavit to perjury go seriously discourage dis kind duplication. The international comparison matter dey important. Countries like the US, India, and even UK still dey see similar disagreements between courts of coordinate jurisdiction, meaning say Nigeria no dey alone, na part of the normal growth of any legal system. The main difference na how quickly appellate courts dey resolve am and how faithful lower courts dey to Supreme Court decisions. All dis angle together show say the judiciary no collapse, e just dey evolve, and na dis evolution dey force the law to mature stronger. When you still look dis matter further deeper, e get some deeper issues wey Nigerians suppose see clearly. One, the PDP convention drama not just expose conflicting rulings, e expose how politicians dey take advantage of loopholes. When person fit file the same case for Abuja and Ibadan at the same time, e automatically open room for different judges to interpret am differently. Na wetin Adejumo dey call for make affidavit become compulsory, so anybody wey lie go face perjury. Dis whole situation show how our justice system dey under pressure from public perception. True, Nigerians dey quick react once dem hear conflicting order, but many no sabi say dis thing na normal part of how law dey mature. The real test no be the conflict, na how fast the appellate courts dey settle am. If Nigeria adopt these reforms now, e go change the whole game before 2027 elections. All those last-minute injunctions, emergency restraining orders, and court shopping wey dey happen every election cycle fit reduce drastically, meaning political parties go plan better and judiciary go work cleaner. Another twist be how dis matter highlight the need for digital case tracking. If judiciary fit implement one unified platform, judges fit know instantly whether similar case don dey another court before dem even touch the file. At the end of the day, my people, the real question no be whether courts disagree, na whether the system get strength to correct itself, protect the law, and keep citizens confident. And as the 2025 Judges Conference dey draw near, one thing clear, the future of Nigerian justice system dey on the table, and the decisions wey dem go make now fit shape how truth, power, and fairness go operate for years to come.